Good evening, friends. And within the short time, thanks for coming to this program, because on hearing the Supreme Court decision on moratorium, I want to continue yesterday's program, because yesterday we have finished saying that the moratorium is still there. That is, the Supreme Court has given stay. Then now today the Supreme Court has given its decision on the moratorium, NPA and interest applicability, and we will start the presentation. That is, yesterday we have seen these four circulars. One is reschedulement of term loan.
Hello.
Working capital loan.
Hello. Hello.
Yeah.
Hello.
So working capital loan we have they given, and the extension of timeliness for resolution of standard assets and asset classification provisioning, reschedulement of term loan and working capital facilities. Wherein in this circular they say that up to 29/2020 that account should be treated as standard. That is, only standard assets as on 29/2020, it has to be those assets which have been treated as standard assets, they are eligible to get the moratorium. Initially, the government has given 3 months moratorium. They use the word 3 months. It is not days. That is very much important in this circular, in this decision. 3 months. That is 1/3/2020 to 31/5/2020, and they have further extended the moratorium to 31/8/2020. This is the base. So if an asset is as standard as on 29/2020, all those assets are eligible to get the moratorium. And the circular says postponement of principal and interest. That is, the borrowers, they are eligible to get the moratorium of postponement of principal and interest up to 31/8/2020. And as per the circular, they say that interest is continued to be accrued. This is where the Supreme Court differs. Still, yesterday we said that whether we have to apply simple interest or accrued interest, and still it has to be decided. That is what we have. That is what yesterday I discussed. And there is no civil effect for the moratorium. This is applicable for all. This circular is applicable for all, or whether it is a MSME or whether it's a other than MSME also, this circular, this court order is applicable. But the circulars which I have discussed is applicable only for non-MSME. But Supreme Court has given the verdict on the loans as a whole. It has not classified. It has not classified MSME. It has not classified other loans. They say that all the borrowers, they have considered all the borrowers as one. This is the highlight of the decision. And we discussed the recovery standard. The account should be as on 29/2020. That is standard as on 29/2020. Recovery of interest is being postponed up to 31/8/2020. And they say that interest debited has to be paid immediately after the completion of the deferment period. That is, after 31/8/2020, the interest has to be paid. And bank has now, they have given the power to the bank to convert the interest accrued portion from 1/3/2020 to 31/8/2020 as funded interest term loan, and this funded interest term loan has to be paid on or before 31/3/2021. This funded interest, they have to convert it, that is accrued interest, they have to convert into funded interest, and this funded interest has to be paid on or before 31/3/2021. 21. And as usual, restoration of DP, that is with reference to working capital. If there is any DP, you need not worry about the NPA. The original DP portion, it has to come, it has to be restored on 31/3/2021. And they have to review the working capital limits on or before 31/3/2021. And downgrading is not possible. That is the bank, they have to maintain the same status. This is what we have discussed so far yesterday. And the Supreme Court has issued its interim order on 3/9/2020, say that the moratorium available up to 31/8/2020, it is that no account has to be declared as NPA till 31, that is after 31/8/2020, after its final verdict. Yesterday I said still as on date, that is up to yesterday, the interim order holds good and it has not been lifted by the Supreme Court. But today we have received the order on this case. What is the order date? The order date is, this is very, very important. Kindly watch. And this is the order dated is 23/2021. Today only they have promulgated the order. The Supreme Court bench, it comprises of Justices Ashok Bhushan sir and Lordship R. Subhash Reddy and Lordship Emma Shah, who has pronounced the verdict in the case of, because the case has been filed by Small Scale Industrial Manufacturers Association, which is a Rejection versus Union of India and other connected matters. So today only the Supreme Court has pronounced its order, that is on 23/3/21. And in this order, they say that the charging on interest, that is, interest is the charge on interest is nothing but just like compound interest, and no penal interest is allowed during the moratorium period from 1/3/2020 to 31/8/2020. This is the very important point in this Supreme Court order. And they say that the government has said that only 8 units, that is loan exceeding 2 crores, they are not eligible to get the waiver of interest. But the Supreme Court has said that all the borrowers are eligible to get the waiver of interest. That we will discuss later. And if the interest has already been collected, and as per the order, the bank, they have to refund the interest or adjust the same towards the future installments. And the court says that there is no rational in the central government policy to limit the waiver of interest only to certain categories less than 2 crores. They have not accepted the government policy of giving waiver of interest up to 2 crores. That they differ with the government policy. And we'll go the case in depth. These are the following 8 categories. Whether the central government in the last year, they have taken the decision to allow waiver of interest only to 8 specified categories where the loan sanctioned amount, it is not outstanding, it is a loan sanctioned amount up to 2 crore loan. It is not outstanding, it is a sanctioned amount. So those categories are, what are those categories? It is MSME loan, education loan, housing loan, and consumer loan, and credit card dues, automobile loans, and personal loans to the professional. So consumption loan. These are the 8 loans wherein the government has proposed to give, has taken a decision to give the interest of waiver, but the Supreme Court says that, has said that the policy with reference to the above point is said to be arbitrary and discriminatory because there is no defined rules and regulations. So they say that the order, that is the policy issued by central government, is arbitrary and discriminatory because it gives the loan only up to 2 crores. They say that all are eligible, not only the loans up to 2 crores. This is the stand that they have taken on this. The court ruled that we are of the opinion that there shall not be any charge of interest on interest. That is, you are not supposed to charge interest on interest, and as well as compound interest. They say that you have to apply only the simple interest. There is no interest on interest, and there should not be any penal interest for the period during the moratorium period. Why they recommended, why they are not allowing penal interest means the benefit is given by the central government RBI to the borrowers. So only those persons who have violated, they are eligible to be charged under penal interest case. Here it is not there, it is not required. So for the period during the moratorium, for any of the borrower, they said any of the borrower, they never say that loan below 2 crores and above 2 crores. And whatever be the amount is recovered, if the bank has recovered any amount by way of interest on interest or compound interest or penal interest, for the period during moratorium, the same shall be refunded and to be adjusted or given credit to the next installment of the account. So that means the interest, that is this is a loss to the bank. This is a loss to the bank, but they have received the interest, but the same has to be adjusted to the loan account. Further, they say that it is directed that there shall not be any charge of interest or compound interest, penal interest for the period during the moratorium, and any amount already recovered under the same head, namely interest on interest, penal interest, compound interest, shall be refunded. Same thing they are repeating. They are repeated to the concerned borrowers by way of given credit or adjust the, either you give the credit to the loan account, borrower's account, or adjust towards the next installment in the loan amount. It is very, very simple. As per the moratorium order, there is no need for the borrower to pay the interest, but the system, it calculates interest on interest, it calculates the interest on compound interest basis, it also applies penal interest. So all these three interests have to be charged only on simple interest basis, no interest on interest. Suppose if 10,000 rupees is interest and next month it charges 10,000, for that 10,000 again the interest. So that has to be eliminated. So only 10,000 rupees interest is allowed. And there is no compound interest. If you go to the principal and automatically the compound interest for the entire period as a whole, for the entire 6 months they are doing, so that compound interest should also not be there. And penal interest. So you are not supposed to charge penal interest as the moratorium is being given by the RBI and there is no default on the part of the borrower. So that is not required. And it is directed that there shall not be any charge on interest on interest. Compound interest is in the nature of penal interest. This is the opinion of the Supreme Court. The compound interest is in the nature of penal interest chargeable on deliberate and willful default by the borrower to pay the due and payable. My question here is, normally the bankers, they are charging all the term loan, they are charging all the cash credit loan on compound interest basis. The simple interest is applicable only for the education loans and government sponsored schemes. And here they say that compound interest is in the nature of penal interest. My question here is whether this only for the definition given in this Supreme Court order is applicable only for this moratorium cases or for the interest as a whole which the bankers they are charging, and we will get the clarification. My interpretation is they say that compound interest is in the nature of penal interest. So according to me, it has to be taken only for the moratorium period and not for the bank as a whole, not for the entire loan as a whole. So this is the interpretation we can have, but we will get the clarification. But according to me, this point number 2 is applicable only for the moratorium, period. Yeah, Abhinav, it is the normal interest. Normal interest means it's a normal interest. If you apply interest along with the principal, next month the principal plus interest will also be charged to again interest calculation. Here they say that what is the amount outstanding as on 29/2, you have to charge penal, not compounded interest. You have to apply simple interest. They say that it is a simple interest. So that means no compound interest is allowed, no penal interest is allowed. And RBI has allowed moratorium. They have accepted that the policy of the government to give the moratorium is allowed, but no compound interest has to be charged as it is not justifiable or justifiable decision, because the benefit is given by the government and the government say that don't pay the amount for this period. So you are not supposed to charge interest on interest. So you have to apply only the simple interest. This is what I observed from the court order. And there is no question of waiver of interest. So a lot of customers, they say that, see, moratorium is being given by the RBI. We will not pay interest. So that means it's a waiver of interest. So the court says, Supreme Court says that there is no question of waiver of interest, as the bankers, they have to pay interest on deposit to the public as well as to the pensioners. So there is no question of waiver interest. The banks, they have to collect the interest, but the charging of interest is only a simple thing, and no penal interest, no compound interest, no interest on interest. This is what I observe from this definition. What needs to be seen now is what the government about this does about this. Will it bear the additional burden of compound interest on the other loans as well? Does it have the physical space? Yes, sir. That's why I said the government. See, they say that during moratorium, not only bankers they lose the profit, not only the business that has been lost by the customers, even the government also they lost lot of things, because they have to spend lot of amounts in the form of all types of public benefits and everything that we'll see in the next slide. Calculation of overdue interest installment to be made on 1/9/20. Yeah, you are correct, sir. You are just above, you are covering that point. So very good. I think it was mine. You are correct. So you have to calculate the overdue interest on installment to be made. Still, we have to receive the bank's policy. We will wait. But as of now, there is no question of waiver of interest. That is what the Supreme Court said. The court has rejected the extension of 6-month loan moratorium period granted by RBI on account of COVID-19 pandemic. So the case has been filed. We want more extension. RBI has not given any extension. The court has rejected that plea that we will not extend that 6 months extension. This is the government policy. They say that the moratorium has to be given only up to 31/8/2020. The court has not extended the moratorium period. They accepted the government decision that moratorium is available up to 31/8/2020. Same thing. They also don't want to extend the the invocation of resolution mechanism and additional sector-wise package have also been rejected, because they say that 180 days plus 90 days, we will not extend that IBC cases or resolution cases which have been pending before NCLT. They are not they will not extend those days. They still support the government policy of non-extending beyond the 90 days cushion given by the government. And the scope, they say that the scope of judicial review is very limited in economic policy matters. And because they say that we have to interfere only to some extent in the economic policy of the government. And they say that the review is limited. And moratorium circular applies to, they say that the moratorium, and see, actually go to 5, in that they say that in the review of the economic policy, they say that it's all financial matters that has to be decided by the central government. They say that the judges are not experts, so they have endorsed the government decision with reference to the financial policy, because it is a country as a whole, the finance ministry and government, they are taking decision. So they know they don't want to interfere into the financial policy of the government. And the moratorium circular, which has been issued by the central government, it is applicable to the banks as well as financial institutions. That means it is this order is applicable to the banks as well as to the financial institution. And the central government has to provide package and relief with the expert advice of the departments, including RBI. Because before providing the package and relief, the central government has got a lot of expert advisors from various departments of the government, including RBI. Then the court will review only the case, only in cases. This seventh point is not only applicable to this case, any case, even in the case of valuation also, the court has already reviewed that, but they already said that the court will review only in case of glaring, only glaring irregularities, illegalities or malafide intentions or that, then only court will interfere. Here, the government intention is correct, and so they are not ready to interfere into the government policy. And what are the writ petitions that has been filed? Everything they have dismissed, and they are not allowing the writ petition, and they have given the decision in this moratorium case, and they have not issued any direction to central government as well as to RBI to provide relief to a particular sector. They say that the government has said that only for the loans up to 2 crores waiver of interest is applicable. They say that there is no particular sector. If you think country as a whole, you have to take for the entire country for the entire loan, and there should not be any restriction. Only up to 2 crores these are eligible. There is no question of that. That point, you have to apply this question of waiver of interest to all the loan, all the sectors. And they also observe that government has also suffered from the economic loss due to unprecedented pandemic situation, as well as they have lost huge amount in the form of the GST revenue. Yeah, Kandavel sir, please explain. Is that what is the extension of resolution profession? Extension. The thing is, normally when any case is filed before NCLT, that case has to be closed. That is all insolvency proceeding cases have to be completed within 180 days, and there will be further extension of 90 days that has also been provided by the IBC. But they say that this 180 days has been added. They have given the extension for further 90 days. That is, instead of 180 days, you have to substitute 270 days. Okay. From there, you can calculate 90 days. So that is available, but people, they want further extension. The Central Supreme Court says that there is no need to give the further interest. Borrower has to pay interest for the period of March to August, immediately basis, waiver of interest up to loan. So I think mine, that is clearly Supreme Court said. I put it in the message applicable to everyone. If you put direct message, that is not only to me. Borrowers have to pay interest. That's why they say that in the Reserve Bank, in its order, they say that all the interest that accrued from 1/3/2021 to 31/8/2021, all those interests have been converted into FITL, funded interest term loan. And this funded interest term loan has to be paid on or before 31/3/2021. This is what circular says. And there is no question of waiver of interest, not only for 2 crores, even for all. If no one wants to give, they have to give waiver of interest for all loans and not for a particular sector of loan up to 2 crores sanction. So pandemic sector also, point number 11, only 7 days to receive the pending interest and regularize the account is a big challenge for banks. Yes, sir, Nagpal. The interest is due on 31/3/2021. From there, you have got 90 days. Otherwise, this loan will become NPL. This is a very big challenge to the bankers. This is also a very big challenge to the borrowers. We hope the government will give some concession for the extension towards FITL, funded interest term loan. We will hope, but we will see because it's a decision of the government. And also they have to save the parties also, borrowers also. We will wait, because as of now, because the court has given its final verdict, now the stay is over. So now everything you have to calculate. Next one is point number 11. Pandemic situation affected all sectors of the country, including the government. This is what they said. It has affected all sectors of the country, including the government. Government in priority has spent the lot of money towards health, medicines, providing food, shelter, arranging transportation to migrants, etc. in the interest of the public. Because the government has invested lot of amount, because they have diverted all the funds only to the benefit of public. Because from the health to the, they have provided, they have taken care towards health and medicines, and they provided food and shelter, because no food is available, there is no one where to stay, nothing is available. So they have given lot of importance to this area. And for the migrants labor, from even from Tamil Nadu to Orissa, lot of people, they have to travel, they want to go to their native place. For that also the government has spent lot of money towards transportation. This is what the Supreme Court has observed in this order. And 13, Center also has taken necessary steps under the various relief packages, including Atmanirbhar Bharat and Garib Kalyan scheme. This is what court observed. They endorsed all the government work. They have accepted that the government has spent very good amount in the benefit of the public. So they say that this is the base of the entire Supreme Court circular. Court rejection on the following relief sought by the various petitions, because these are the ground of 1 to 5. This has been these are the relief that has been sought by the various petitioners. They say that we want total waiver of interest during moratorium period, and court says, Supreme Court said, there is no question of total waiver of interest. You have to pay the interest even during moratorium period, but that interest calculation has to be done on simple interest basis, without charge, without calculating, without applying interest on interest, without applying the penal interest, without applying the there is compound interest. For that, you have to do it. And to extend the period of moratorium, everyone has said that please extend the moratorium. They say, no, we will not extend the moratorium. They say that the government decision of extending moratorium up to 31/8/2020 holds good. We will not recommend for any further period of recommendation towards moratorium. They say that it's a financial policy matter that has to be considered by the government. Yes, sir. Nakpal, sir. Very good observation. It has already crossed 100 members, and thank you very much for all the participants, all the members who have come here. And still I have to reach another 40, because 140 was the maximum attendance for our program. And that there shall be sector-wise relief provided by RBI. Sorry. Point number 3. To extend the period of invocation of resolution mechanism, namely 31/12/2020, provided under 6/8/2020, they say that no further extension of the IBC cases. It is, the government says the moratorium is applicable only up to 31/8/2020. We will not extend. So the court is not ready to extend that period also. And fourth one, they say that the petitioners, they pleaded that we want relief, and not all. They say that there is no sector-wise relief. That means less than 2 crores, above 2 crores. All the borrowers have to be treated as a whole, and there should not be any sector-wise relief. So this also they have rejected. And central government, when the Supreme Court has said that the central government and RBI must provide for some relief provided over and above the there is schemes already offered, all stand dismissed. They say that the relief given by the central government, the relief given by the RBI is final, and they have not recommended for further extension of relief given by central government. They have further extension of RBI, further extension of further extension of relief given by central government and RBI. So once again, the court has summarily rejected the point number 1 to 5. This point you have to bear in mind. One is total waiver of interest. Sorry, we will not extend. And we will not extend the moratorium period. Moratorium period, it is applicable as of now to 31/8/2020, and no further extension in IBC cases. And we will not consider the applications on sector wise. As a whole, we have to consider. And there should not be any disparity between the borrowers. All borrowers are equal, whether they are right, whether they obtained 2 crores, whether they obtained 200 crores, all are equal. And that the court also said, we will not recommend for further relief for the relief given by the central government and RBI. And what are the serious questions I want? See, this is my thing. All sectors are eligible for moratorium for waiver of interest. That point we have to accept. What about NPA? NPA due to loan sanctioned about 2 crores. If it is declared as NPA due to non-repayment of interest, sometimes because the concession is given only for loans up to 2 crores. In case if any of the banks they classified the loans above 2 crores under NPA category, what is going to be the effect that we have to see during the audit? Then how to calculate the NPA after moratorium? This is what very, very important. This I worked out to the best of my knowledge. And if anyone can give any suggestion, if they want to raise any question, they can also raise, because this is a first time I am presenting the case. Even you can differ also with me with my working. Even that is the case, you can share your experience here also, sir. Next point of slide is NPA working chart as per the as per what's that? 1 second. According to me, how to calculate NPA? This chart is my working. This is what I felt. Still a very good number. Yeah, this is my working, and this you can take it as suggestion or reference. And if you want to do it on your own, you can do it. I'll just clarify this. And the status has to be calculated. This is very, very important. Third point, the status has to be calculated by exempting moratorium. Once again, I'll repeat, on 29/2020, that account should be a standard asset. If it has already been as substandard asset before 29/2 or on 29/2, you need not bother about the NPA classification. You have to do the regular IRAC norms. But what if the NPA falls between or during the moratorium? For that, we have to decide, because we are going to the audit for the months on as on 31/3/2021. You have to do it. Yeah, Deepak Agarwal, you can ask the question. I have a question. Yeah, you put it in the chat box and
yes.
Put the question in the.
Yes, sir.
Instead of sending
yes, sir. Yes, sir. Sir, my question is, am I audible, sir?
Yeah.
Am I audible? Yeah. Thank you, sir. Thank you. My question is, this writ petition was 476 divided by 2020, right?
Was it?
This writ petition number was 876 divided by 2020, right?
Yes.
And the other writ petition filed by Gajendra Sharma, that was number 825 by 2020.
Yes, sir.
Right.
Tell me, sir.
So my question is, there is no mention of that writ petition of 825 in this writ petition. In this order, there is no mention of Gajendra Sharma writ petition. So how to decide about that interim order has been now vacated? My question is that.
Yes, sir. For your kind information, even I want to accept one thing. I have not gone still to the entire. Order.
No, sir. There is one clue. You can use Control plus F to search 825, right?
Okay.
So in this PDF, you can search by Control plus F and you can find 825 if it has been mentioned anywhere.
Sir, and they say that in the
if you read on the
all the writ petition.
Yeah, sir, if you read on page 148, right? The judgment is on page 147 and 148. So if
Yes.
you read the first two lines on page 148, they clearly say that the interim order has been now vacated. But they don't mention about the that writ petition number.
Which has already been filed.
Who's yeah, sir. So I need that clarity.
Sir, I do accept, but
Yes.
only on reference I'll give. As of now, based on the present thing, I have prepared everything in the interest of the members. And
Right, sir. Right.
you have pointed out, even
So,
if it is differs estate, I mean tomorrow, if I find anything, then definitely I'll circulate that to every members.
okay, sir. Thank you, sir. Thank
Yes, and thanks for your immediate that observation about the.
Yes, sir. I actually little bit yes, sir. I little bit analyzed in afternoon this this actually by downloading this order that time.
Okay, and if you had already downloaded the order, you can share to me so that I can share to everyone.
Okay, sir. Sure. I'll share.
Okay.
I'll share that.
Thank you very much, sir. And
Okay.
the status has to be calculated by exempting moratorium. So this is what they said in the order. So what I observed from the order, they said no extension of moratorium. So okay, so the due date of 29/2/2020 has to be shifted to 31/8/2020. After that, you have to apply the NPA working. This is the way in which I observe, and I tell why I think like this. We will say up to 29/2/2020, all accounts are standard. In case on 1/3/2020 that advance has become NPA, that is the NPA due date is 1/3/2020. The moratorium, the government say that those accounts should not be classified as NPA till 31/8/2020. In the order, you observe that they have extended 3 months and not in days. They say that they have extended 3 months. So 1/3/2020, that is NPA. Now the due date of 1/3/20, it has to be for. I mean, you have to take the NPA cutoff NPA date as 1/3. Sorry, it should be taken as. Sorry, I wrongly. You have to 1 second. Be 19. Fine. Yeah. Now it's okay. It should be taken as 1/3/2020 because they say that up to moratorium, the period is 31/8/2020. Now the due date is you have to add 6 months to 1/3/2020. It comes to 1/9/2020. See, go to the RBI order. They say that it has been moratorium has been given in the form of months and not in the form of days. So this is what I observed from the presentation in the seminar, Mr. That there is that this time no need to issue MOC. Sir, that is old one, sir. That is old one. Okay, in the meeting they would have said this, but as because they have reported based on the what's that, Mike, sir? You said in seminar, Mr. Rejection Sopraji mentioned that this time there is no need to issue MOC for NPA. A lot of confusion on NPA lookout and classification. So it's very, very simple. You just observe my presentation in the form of the chart. And the thing is, my observation is you have to do the NPA calculation even from the last year. So you have to see the NPA for 1920 also. From there only you have to arrive at the present year. This is what I observed. And now you have to do it. Now you have to do the NPA calculation. And the writ petition. Yeah, Janak sir, thank you for me for your immediate thing. Writ petition 825 already Supreme Court had given verdict on 27/12/20. Then Gajendra Sharma was satisfied with the ex gratia scheme. No further case. The aforesaid contention were resolved to the satisfaction of the petitioner on a wide ex gratia scheme dated 23/10/2020, and they were satisfied with the ex gratia scheme and no further case. Okay, and now we are going to calculate. We are going to concentrate on the calculation of NPA in case because they say that it is a 6 months. So 1/3/20. On 1/9/20, that is the new fresh, fresh NPA due date. 1/3/2020 due date, you have to shift to 1/9/2020, 2/3/2/29, 28/3, 28/3 plus 6, so 28/9. 31/3 add 6, it comes to 39. It is not 31/9, it is 39. Here there is a confusion whether we have to shift to the next month. So that we have to get it clear. As of now, they say that only 6 months. So they never mention about the days. And if the due date falls after the 31/10, in case of this one, 31/3/2020, if we add 6, it works out to 39. Whether the due date has to be shifted to 31/10 or 1/10, that is not clear so far. They say that they have to add the 6 months. We will get, I think soon it will be cleared by the RBI. We will wait for the thing, but as of now, it is 6 months. What is the end of the 6 months? So 6, 3 plus 6, 9. And 34, if you add 6 months, it is 35/2020, because that is 31 days. 34 is 35, 36 is 30/12, 31/7 is 31/1, and 31/8 is 28/2. So here, once again, this is a problem. 9, 10, 11, 12, 1, 2. So they say that it is 6 months. Only the month is extended. They never say that dates. If the month is extended with the date, it is 28/2/2021. Once again, I say that this is my interpretation, sir, and we'll wait for the clarification. I've already sent a mail to get it clarified to the appropriate forum. I already sent. We'll wait for the direction before the commencement of audit. We'll get it. And 39/2020 add 6 months. It come to 33/21. And this chart is only of temporary nature. I want to say this chart is only a temporary nature. To avoid confusion, I have prepared this. And 1/10/2020, the due date is we add 11, 10, 11, 12, 1, 2, 3. If you say 1/10, 11, 10, 11, 12, 1, 2, 3, and April, that is 6 months. So it comes to 1/4/2021. It is not, is it not? Yeah, Kandavel sir, we will get still we have to get it from the, how is the due date of NPA? 34/2020. You have to add 6 months. Sorry. Okay. So I have to do correction. You have pointed out correctly. It has to be 30/10. Yeah, you are, Kandavel sir, you are correct. 34. Yeah. Now is it okay? See, I've only left with 1.5 hours to prepare the entire PPT, because I thought of doing the seminar. I've hardly left with 1.5 hours. So with this, I've prepared the PPT. So I think now it's okay. If there is any mistake also, we can do it. And you have to see that everything extends beyond 31/8/2020, because the NPA starts from 30, that is after 31/8/2020, you have to do the NPA working. And this is what I want to say here. And thank you very much. And if you have got any doubt and if you have got any suggestion, you are welcome, sir, because this presentation is according to me only. What I thought, I said to you. If you want to refresh it, or if you want to add anything, you can do it. Date should be 31/10. Yeah, Manikumari, I have rectified it. Sir, please explain. NPA will be after 180 days. So I said NPA after not 180 days. NPA date, I fixed the NPA date. Arrival of NPA date is as per, usual IRAC norms. So I have shifted only the NPA date to new NPA date. I have not calculated 180 days from the NPA due date, because the moratorium is available only up to 31/8/2020. Nagpal, we have to please explain. NPA will be after 180 days. I have shifted in my presentation, I have shifted only the NPA date to the next date, next thing. If you got any doubt or any suggestion, so that other members they want to see, then they can, we will discuss that also, sir. Sir, whether 6 months extension is applicable for the accounts becoming NPA till 31/8/2020 and for the accounts becoming NPA after 31/8/2020. So all those NPAs which have fallen between the moratorium period. During the moratorium period, if any account has become NPA, that NPA due date is being shifted. That's all. Normally, even one can say that the NPA due date is 31/7. Okay, they say that 6 months moratorium ends on 31/8. Can it be 1st September? That is also another question I want to say. I want to ask. See, the 34/20 is the NPA date. Okay, here it is. He said whether we have to add 6 months from 34 or we have to fix the due date of moratorium on is 1/9/2020. Or is it correct or not? So this we have to get the clarification. If you, so the thing is, if 6 months is being added, then we have to add for everything. This is what I thought, but now I thought 31/3 the cutoff date is 31/8. The any NPA during 31, that is moratorium, will automatically become deemed as NPA on 1/9/2021. This is what the clarification that we have to receive, and this is the separate session. But my intention in Supreme Court decision, there is no interest on interest. There is no, you are not supposed to calculate compound interest. You are not supposed to calculate penal interest. This is one. And no further extension is being allowed. And no IBC cases further extension is being allowed. This is what the Supreme Court says. So how to calculate NPA? Still we have to get the reference from the Reserve Bank of India. So even one can say that, sir, any NPA due during moratorium period, the moratorium ends on 31/8/2020. So 1/9/2020, all account become NPA. This is also you can get. Sir, Yogeshili, I will upload everything in the YouTube. 2 videos so far I uploaded. Still I have to upload 4 videos for want of time, and I got a little problem in my laptop. So that also, that will be rectified soon. Definitely I'll do it, sir. Deep Agarwal, you said anyone is recording it. I don't know, but I said it has been, according to me, I am recording this program. And I decided to conduct long form audit report. Okay, one. And second one is verification of loans and advances. Third one is reading of sanction letter. And fourth one is bank frauds. And another one is NPA, NPA calculations. All this 5 programs I want to conduct. I think we are on 23rd. I think before 29th, I'll see that all will be completed, so that whenever you are going for audit for 31/3, after 31/3, it will be helpful to you. This is what I plan. Let us wait. Let us hope for the best. Because all the thing I've already, every program is going to be taken by me only, and still I'm just having talk with 2 of my friends. Can you explain NPA in September 20? Yeah, NPA in September 20 and 6 months. This is what I said. But even on September 20, you have to do normal NPA. Monica, you have to do regular IRAC norms. So the question here is whether the moratorium is applicable from NPA due date to and 6 months, or all the NPA due during the moratorium will have the NPA due date on 1/9/2020. This question we have to get it to be clarified from the Reserve Bank of India. Sir, we can give MOC for that. Yes, if it is NPA and if it is being regularized after that, you can upgrade it. If it is NPA, you have to give the MOC. So there are two interpretations here, whether the NPA due date has to be added with 6 months or all the NPA due dates during the moratorium has got the NPA due date on 1/9/2020. Definitely it will be clarified by RBI soon. We'll wait for that circular also. And because they have to make a lot of provisions for this, they already always said that it is the, if the stay has not been lifted, they will face a lot of problems. And I think the court has given the verdict on right time. We will wait for the opportunity. Even only one clarification from this, even this presentation which you are seeing in the screen is the NPA due. The 6 I have calculated the morality period and added 6 months. Whether it is correct or not, I don't know, because for the purpose of discussion, I have prepared this. Even I am of the opinion that all the NPS during the moratorium has got a NPA date of 1/9/2020. This is also my view, and we will hope for the best. We have to get it clarified by RBI soon, in a day or two. And thanks for the opportunity given. And within short time, you have crossed. The total attendance I have observed is 103 members. So very good, fantastic attendance. And it's a point I have initiated. And if you have got any suggestion, any view differ to this, you put it in the group so that is known to everyone. And with this, I'm just signing off. And if you have got any doubt, you can put it. Yeah, Deep Agarwal. We will start with LFAR, bank frauds, NPA, loans on advances, and reading of sanction letter. That is very, very important and for you. That is very, very important to you. That also we will discuss. Where to find your PPT? If possible, sir, go to my YouTube, Ravindran V. Deep Agarwal, go to my YouTube, Ravindran V. You will get all the presentation recorded and you can see that. I've already uploaded 2 and I hope today I'll upload all the remaining session. And in my YouTube, I've already released 81 YouTubes relevant to the bank audit. Almost all bank audits videos are there. Any youngsters, if they want to go line by line also, they can learn on seeing that YouTube. And within this, within 3 days, I've got, my subscriber has been increased by some 42 people, 42 young new entrants I've got. That's also a very good response to my YouTube channel. Thank you very much. I'm just closing the session. Sir, one session on CBS. Yeah, Yogesh Chidar, that's what I want to say. I've just consulted my friends because I am not well versed in the computerized operation. But I know how to question and where to question, what to question. But I'll get the date of that faculty, and also I want to contact bank and GST. Bank and GST. That is also another topic I want to share to you. all this entire week is going to be, when you'll be busy, and even I don't want to disturb you because the year ending, it's a year ending also. We'll see, and to the maximum extent we'll cover. Thank you very much. I'm just going.